It's 2024. We are still talking about, guess what? Pistol braces.
No, God!
Yes, the monstrosity, the abortion that was the ATF final rule is still unfortunately with us, or at least we're dealing with the afterbirth. And specifically, we're talking about the 8th Circuit Court of Appeals. We're talking about the Firearms Regulatory Accountability Coalition, Inc.
No, God, please, no, no!
Also known as FRAC, F-R-A-C, versus Garland. So FRAC versus Garland. This is the case that started out in North Dakota. The district court judge, recall we've got district court judges, that's the federal trial court. Those kick it up to the 13 federal circuit courts. Those are the circuit courts of appeals. We're in the 8th one. That means we're talking about North and South Dakota, Minnesota,
oh my,
Iowa, Arkansas, Missouri, and Nebraska. So that's the 8th Circuit Court of Appeals. That's what we're talking about here. They are finally doing something about pistol braces. Yes, the 5th Circuit Court of Appeals have stepped in with an injunction, but since that is technically still going on, set for oral arguments, by the way, in September, so we are still following that, that means that yes.
No!
The rule is on life support, but it is still alive. Will the 8th Circuit finally strike it down? Let's check it out, guys. Let's get into it. Okay, so we're going to try to quickly and somewhat methodically move through this. So we're talking about pistol braces. Pistol braces, for those of you who may not recall, because, hey, you haven't had to think about what that felony might be doing in your trunk or somewhere in your basement. Those are those things that you get attached to the heavy pistols. We're talking AR-15s, we're talking AKs, things like that. And they allow you to stabilize it nominally for one-handed purposes, nominally according to the ATF, because, of course, the ATF says the real reason for them, at least for the vast majority of them, and by that we mean something like 99%, if not more, is basically just to circumvent the short barrel rifle laws, which we have thanks to the 1934 National Firearms Act. If you're new here, National Firearms Act was one of the very first pieces of federal legislation that regulated firearms. It basically said that certain types of firearms are highly regulated. They are not illegal, they are highly regulated. We're talking about things like short barrel rifles, short barrel shotguns, AOWs, that's any other weapon, machine guns, so forth. Did not make them illegal, just made them highly regulated. If you don't pay to play with the regulatory game, so if you don't participate, jump through the hoops, send in everything to ATF, guess what? Straight to prison. You're looking at generally 5-10 years even per item. So why are we talking about that here? We're talking about it here because back in 2012, the ATF took a look at this device and they said, yeah, good to go. This is perfectly legal. You can manufacture these and sell them. Doesn't fall under the National Firearms Act, doesn't turn your firearm into a short barrel rifle, henceforth known as an SBR, short barrel rifle, doesn't do any of those things. And then they kept backing that up and backing it up and backing it up, and more companies kept jumping into the game. Now, some people started taking pictures, there was some marketing, of course, YouTubers got involved. Can't trust YouTube guys talking about guns, believe me, I know. And basically people started, using them as a device that you could shoulder fire with. So now we've got people firing a firearm from the shoulder that has a barrel less than 16 inches. We care about that. At least the ATF cares about that because the definitions of becoming a short barrel rifle, in part, a short barrel rifle governed by the National Firearms Act and a felony unless you pay to play, is any rifle having a barrel or barrels of less than 16 inches in length. That's section 5845, sub A, sub 3. Or a weapon made from a rifle if such weapon, as modified, has an overall length of less than 26 inches, or a barrel or barrels less than 16 inches in length. That's the next sub 4. So section 5845, sub A, sub 4. And the basic definition of a rifle also comes from this section. Rifles are regulated as, quote, a rifle is defined as a weapon designed or redesigned, made or remade, and intended to be fired from the shoulder, end quote. Now, this is important because pistols and revolvers do not fall under the purview of the NFA. They're not firearms for the purposes of the National Firearms Act. So just having a barrel length less than 16 inches that is designed to be fired from a shoulder is now subject to the NFA. All right, so now I want you to go in your mind's eye back to June 10th of 2021. It was a beautiful early summer day, depending upon where you are. Maybe it was beautiful, maybe it wasn't. I don't know. Just stick with me. The ATF introduced a new worksheet as part of their public comments, Worksheet 4999, which would, quote, allow individuals or members of the firearms industry to evaluate whether a weapon incorporating a stabilizing brace will be considered a short-barreled rifle or firearm under the Gun Control Act and National Firearms Act. Now that's shorthand, because I realize not all of you speak governmentese. That is shorthand for do this math to determine if you go to prison. That's what that means. Now, I linked in the description box below a link to the 4999. Hopefully Derek's showing it on screen right now. What you need to know is this. No one asked for this system. No one saw this coming. It was confusing, complex, and you basically needed a team of actuaries armed with TI-84s to figure out whether or not you were committing a felony. The comments were brutal. They were ruthless. They were overwhelmingly negative. And when you added that whole thing up, the ATF basically paused in their tracks. Now, this is important because that was basically them putting out a, hey, we're looking at making this rule, the public can comment on this. Now, rather than withdrawing that altogether, or rather than as well putting that forward as the final rule, they did something very, very different, and that has caused them an immense amount of legal pain. And I assure you, if they could go back in time, they would change this. Just trust me, they would. Okay. Really quickly, you are not going to want to miss, and I promise you, I have been around for a couple blocks now. I have never seen the government have this much gall in its arguments. You have to build up to it, though. It's going to be near the end. Stick with me. I want to hear what you think about it in the comment field down below. Hit that like button. Back to the video. About 18 months later, the ATF published their rule in the Register. Now, what they did is they basically completely abandoned Worksheet 4999. That's the one that everybody had notice about, had input on, all those sorts of things. They abandoned the notion of a point system altogether. And now they changed it to a two-step multi-factor framework for evaluating whether or not you go to prison. Whether your braced weapon is objectively designed and intended for shouldering, which would make it an SBR, which puts you in prison. Now, at the first step, and I'm not going to bore you in all the details, at the first step, the ATF basically probes the question of whether or not the weapon was equipped with a stabilizing brace, whether that provides a surface area that allows the weapon to be fired from the shoulder. People, this is important because I'm going to connect all the dots. I'm just putting the chess pieces on the board right now. This is boring. Don't crash your car. Stay with me. If the answer is yes, then the ATF launches into 6 other factors. I know you don't care about them. I don't care about them. I put them in the description box below. I'm going to reference one of them later. I'm holding up a 2 because I'm actually going to be talking about 2, but only one from those 6. Here's the bottom line that you need to get out of this, okay? The ATF theorized that under its new definition of rifle, quote, approximately 99% of pistols with stabilizing braces will be classified as you go to prison. Classified as rifles, meaning you go to prison. I know what you're thinking. Tom, I pay so much in taxes. Is this what my government is trying to do to put me in prison? The answer is no. They did a whole lot more. They made 2 very helpful slideshows, which I've also linked. These are available for free, your tax dollars at work, on the ATF website. The first slideshow contains 32 photos of common weapon platforms with attached stabilizing brace designs that are short barrel rifles. So you got 32 examples of what they are saying is a felony and you go to prison. You notice what they don't show you though. They don't show you how they did the math. Now remember in high school or whatever it is you kids went to, right? You probably had to show math. You probably had to show the work. You can't just go answer, right? I don't think they do that anymore, but I don't really know what they do, okay? High school teachers require a student to show your work, but the ATF doesn't show their work, or maybe they can't show their work. I don't know which, but either way, they don't do it, which is interesting considering the fact that they're the ones that both wrote the test and invented the science that the test is based off of. But they're not going to actually show you why it works that way. They're just going to show you the results. But wait, I mentioned there's a second slideshow. So they're going to fix that. Right, ATF? You're going to show your work in the second one. Right? No, of course not. The second slideshow contained, this time, 35 photos, in case you didn't learn your lesson with the first 32 photos, of, quote, commercially available firearms equipped with a stabilizing brace that are short barrel rifles, end quote. That's code for 35 more examples of how you go to prison by doing what the ATF said was perfectly legal just the day before. So what's really the point to these slideshows? Just to show you that basically everything is a felony, that you were warned so that if you go to court and say, look, I had no idea, like they said this was all legal, the box said it was legal, the guy at the store said that this was all legal, the ATF repeatedly said this was legal. No. They basically made this, speaking as a trial attorney, they made this to be the exhibit against you in the prosecution to throw you in prison. Make no mistakes. That's what they made this for. The exhibit in your felony prison trial. But of course, don't try to figure out their Gnostic math because you don't need to know how they know it's a felony. You don't need to know how they do the math. The bottom line is they're the experts and you need to get on board. That's really the bottom line here. Now, the ATF claims that the slideshows are for placing the public on notice that listed firearm brace combinations are likely to be classified as short barrel rifles under the final rules considerations. Final is in brackets there. That's part of a quote from the case. That's important. Stay with me. Again, we are still putting chess pieces on the board. We're about to start moving them. And you know, sometimes even I'm a little surprised and impressed at the gall that our government can work. This is going to be one of those times. Now, despite the fact that, and I'm going to read from the court so you don't think I'm just being histrionic, quote, the final rule represents a sea change in how the ATF evaluates stabilizing braces. It rescinded all previous braced weapon classifications, declaring them no longer valid, end quote. That's from page 14 of the decision linked in the description box below. So, despite the fact that ATF said this, then they came out and said, well, maybe we're going to do something a little different. And then they just said, screw everything. We're doing this. You don't need to understand how we do it. The bottom line is prison. That's your takeaway from these slideshows. Well, hold on. So this group called FRAC, along with many other groups, but FRAC sued, saying that this was a violation of the APA, or the Administrative Procedures Act. You have to remember, the ATF, they are not a legislative body. I know that's shocking to some of you in DC, but believe it or not, they're not. Agencies, and there's 430 some odd agencies and sub-agencies across the United States, agencies are allowed to pass clarifying rules and they're allowed to make reasonable interpretations that exist within the confines and purview of the statutes that have been set out. That's code for Congress can't pass a law that anticipates every possible application of that law. So agencies can make reasonable interpretations based upon the text of those laws and how they can be interpreted and applied. But they are not allowed to reinterpret them, or as the ATF likes to say, clarify them. If they try to interpret them in a manner that is arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with the law, they're now in violation with the Administrative Procedures Act, the APA. That's the law that governs how they are allowed to do a lot of things. And if that's the case, rule goes. Okay, so that's relevant to your interests and mine. So how do we know in English whether or not an agency's decision, like the ATF here with the pistol brace, qualifies as being arbitrary and capricious? Well, the court starts with this quote. I'm going to read it in part. Quote, the agency has relied on factors which Congress has not intended it to consider, entirely failed to consider an important aspect of the problem, and then it kind of trails off into some other criteria. But I want to highlight, a decision could be arbitrary and capricious if the agency has relied on factors which Congress has not intended it to consider. Okay, so back to that classifying criteria. When Congress said, hey, if a firearm, and I realize this is not exactly correct, but if a firearm is less than 26 inches of overall length, there was a barrel less than 16 inches, and the ATF says, I got it, I hear what you're saying, barrels less than 16, overall length less than 26, rear surface area. That's what you want us looking at. Right, boys? Right? That's what the ATF basically did. And the court says, yeah, That's not what the statute is about. That's not what Congress is about. Or when you get to that 6-factor test and the ATF's talking about marketing and community use factors, that's code for how manufacturers, distributors, retailers, as well as how all of us in the gun tubes talks about these things for potential use. And people are shouldering it rather than just using it as a pure stabilizing brace. Did Congress talk about that as part of the classification process to determine whether or not something's an SBR or not? Because apparently they didn't. I checked the statute. Did not see it. But I promised a doozy. I teased a doozy. Here it is. The ATF says, you know what? None of this matters because it's not a final agency action. Now keep in mind, you going to prison, you destroying your property, you forfeiting thousands of dollars, you hiring attorneys, you doing all these things, none of that matters because you're doing it about something that's not a final agency action. That's what the ATF is saying. FRAC does not have, in essence, standing to sue them because we're doing this before it's a final agency action. Again, broad strokes here. To this, FRAC says one word: slideshows. You are telling us in these slideshows what is illegal, but of course not how. How is telling us what is illegal not a final agency action? The court agrees. The ATF argues that slideshows are not final agency actions themselves because they have no legal consequences. The slideshows are merely meant to, quote, inform members of the public of how they might be impacted, end quote. Yeah, you go into prison and being forced to destroy maybe tens of thousands, hundreds of thousands, maybe millions of dollars worth of inventory. That doesn't matter because it's just how you might go to prison. It's just how your stuff might be forfeited. It's how you might be raided. And therefore, none of that really matters, according to what the ATF is arguing. You didn't see that coming. Be honest. You did not see that coming. You're kind of impressed with what they pulled out. I have to admit, that's a power move. They're really reaching into the government bag of tricks on this one. The court in a nutshell is simply having none of this. Both slideshows purport to show photos of weapons that are short barrel rifles, and the final rule, notes the court, commands actions such as registration in the National Firearms Registry and transfers record that will need to be taken. That's check out page 23-24 of the decision. Quote, we take slideshows at their word. The ATF judged the pictured weapons to be short barrel rifles, which carries direct applicable legal consequences, end quote. So at the end of the day, despite the government's bag of Gnostic wizardry, it's not going anywhere. So what does this all mean? Well, keep in mind, we only have an injunction down in Texas out of the Fifth Circuit, right? That's where that case all stands. As I mentioned, oral arguments coming up in September. This case, believe it or not, this is all being decided on what's called a preliminary injunction. So we basically now have overlapping injunctions, except the Eighth Circuit did not quite order an injunction because they basically say, look, the trial court, these are the guys, or the guy in this case, who is in the best position to basically write what the injunction should say. So they basically said, yeah, there's going to be an injunction, but we're kicking it back down to determine who's going to be covered, who's not going to be covered, what this all looks like. So we know that this is a victory. We don't know exactly how wide or narrow it might go. Let me know in the comment field down below if you want to place your bets on what you think this might be. But that's where we're at. So there's going to be now 2 injunctions in place. We will see where this all goes. Of course, everyone's going to be watching what happens down in Texas in the Fifth Circuit. We'll be following it. Let's close with our quote of the day. This one comes from noted American thinker, writer, and framer Thomas Jefferson in a letter to James Madison, who wrote, I prefer dangerous freedom over peaceful slavery. Bold words, bold vision. Where do you think it's going to go? Let me know in the comment field down below, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.